There are some initial steps we can take to ensure U.S. leadership on AI policies. I think it's critical that we include IP considerations in ongoing AI regulatory frameworks and make certain the U.S. Patent and Trademark Office has a seat at the table. We should change our patent eligibility laws, and I suspect my colleague agrees, so that we can protect critical AI innovations. And last, we should consider whether other changes to our patent laws or new and unique protections may be necessary to encourage innovation in AI and emerging technologies. I am excited to explore these issues with you today with Senator Tillis' cooperation. We have a superb panel with a diversity of views and perspectives. You will, I suspect, find 5 minutes, a bracingly short period in which to explain them. We are grateful for your lengthy submitted written testimony and look forward to your individual summaries. But first, I'll turn it over to Senator Tillis before I introduce our panel. Senator?
Thank you, Chairman Coons, and thank you for another great hearing topic and opportunity. Before I make a few brief remarks, I'm just curious, could anybody, if you're under the age of 35 out there, would you raise your hand right now? Okay. So I kind of bring up the average a little bit, but even this old guy is pretty interested in this subject. But thank you all for being here. I think this is one of an endless number of hearings that we're going to have to make sure that we get it right. And it's great to highlight the importance of intellectual property. Within about 24 hours of ChatGPT offering its beta site, I signed up. I had back in the mid-'80s, I was actually working in AI when the state of the art was character recognition, pattern recognition, and voice recognition. So we've come a long way since then. And as the tools continue to explode, the challenges are going to be great. So this is a good starting point. I think the one topic, everybody's talking about all the bad things that could happen with AI, iRobot, the zombie apocalypse, and then I'm in the good things that are going to happen category. And even if we chose not to participate as a nation, it's going to happen. So the question is whether or not the United States is going to maintain a leadership position in innovation and what I think is one of the most promising spaces for future innovation that we have today. But we're having this hearing. We're going to have AI is going to have a massive impact on intellectual property. And I think this hearing begins to allow us to start parsing this up into issues related to patents, into issues related to copyrights, and any number of other subjects. So I'm going to submit my opening statement for the record. But the key here is if anyone on the panel thinks that AI is bad and we got to avoid it, then we'll agree to disagree, but I'd be interested in your comments. What I'm most interested in is seeing how this new tool, this new capability is going to continue to make the United States of America the historic leading innovator, and I look forward to your comments.
Thank you, Senator Tillis. I'm now going to turn to an introduction of our witness panel. We welcome 5 witnesses to testify about the intersection of AI and patents, innovation, and competition. Our first witness is Corey Salsberg, a Vice President, Global Head of IP Affairs at Novartis, a global healthcare company. He's responsible for defining and developing Novartis's core positions and directing its advocacy efforts with respect to IP law and policy. Next, we have Laura Sheridan. Ms. Sheridan's Head of Patent Policy at Google and advocates for an effective patent examination process, a patent litigation system that operates fairly for all, and transparency in these areas. She's part of the IP Owners Association, a delegation to IP5 industry, and a group which engages the IP5 offices on procedural harmonization matters. Next is Ryan Abbott, Professor of Law and Health Sciences at the University of Surrey and an adjunct professor of medicine at UCLA. Professor Abbott's the author of The Reasonable Robot, Artificial Intelligence and the Law. He also leads the Artificial Inventor Project, representing Dr. Stephen Thaler in the global legal test cases seeking IP rights for AI-generated inventions. Next, we'll hear from Professor John Villasenor. Professor Villasenor teaches law, electrical engineering, and public policy at UCLA, where he founded the UCLA Institute for Technology, Law, and Policy. His work considers the intersection of technology and law in areas including artificial intelligence, digital privacy, and the technology supply chain. He's written on the implications of AI in relation to patents. Finally, we have Rama Elluru, Senior Director for Society and Intellectual Property at the Special Competitive Studies Project. She leads a team working on shaping AI governance and IP policy previously served as staff to the National Security Commission on Artificial Intelligence. She led the NSCAI's IP efforts and worked on the ethical and responsible use of AI. After I swear in our panel of witnesses, each witness will have 5 minutes to provide your opening statement. I know that will be difficult, but please restrain yourselves. We will then proceed and have each senator question for 5 minutes, and we will do our best to live within those limits. I hope we will have time for a second round of questioning. It really depends on how many of our colleagues join. So could you all please stand to be sworn in? Please raise your right hand. Do you swear or affirm that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Mr. Salsberg, you may proceed with your opening statement.
Thank you, Chairman Coons, Ranking Member Tillis, Senators Hirono and Blackburn, and distinguished members of the subcommittee. My name is Corey Salsberg, and I am Vice President and Global Head of IP Affairs for Novartis. On behalf of the company, thank you very much for the opportunity to testify today. Today's hearing is timely and extremely important because, as everyone in the room knows, AI is already here. It's in wide use across industries and society, and it is fast shaping our future. As an early adopter of AI in the life sciences, Novartis is using today's AI tools to help us accelerate drug discovery, to make our clinical trials more efficient, and even as an aid in molecule design. As some examples, machine learning tools are helping us more quickly screen the millions of compounds in our libraries to accelerate the selection of candidates with desirable properties such as the ability to bind to a disease-implicated target in the body. Our AI-enabled platform, NerveLive, uses AI tools to help us anticipate and resolve operational issues at our thousands of global clinical trial sites. And in a field known as generative chemistry, our scientists recently trained, guided, and used our AI-enabled research platform called Jaeger to assist in generating new virtual molecules for potential use in treating malaria. Tomorrow's AI tools promise to expand on these activities and enable many more, helping us to unlock medical insights like the secrets of the human genome and to ultimately develop more effective, personalized, safe, and efficient medicines. What this means is that the time is right to ensure that the right laws and policies are in place to enable that future. But the right policies depend on the right information being shared and the right questions being asked, which makes this hearing especially timely. While everybody knows that AI is here, not everyone understands or agrees what that means. It's easy and perhaps tempting to equate the outputs of a generative AI chatbot or the familiar sounds of an AI-generated pop song with human-level thoughts and creativity, and equally easy to assume that the role that AI plays in one field or situation is the same as in all others. But when it comes to AI, ubiquity does not mean uniformity. Last month, with reference to our Jaeger platform that I mentioned, a headline in Politico posed the question, can Jarvis hold a patent? Apparently referring to the fictional artificial superintelligence entity Jarvis in the Marvel movie franchise. While this may make an intriguing headline, and it certainly delighted my 3 kids, Jaeger is not Jarvis. And whether AI can or should be awarded a patent is not, in our view, the right question at this point in time. As a foundational matter, before addressing whether AI can earn or own a patent, the right question is whether today's AI is even inventing. In our experience, as a matter of fact, the answer is no. At least in our field, AI tools today are still just that, tools that are helping to facilitate, optimize, and enhance human activity and ingenuity and to advance human-defined goals. Non-generative machine learning tools that improve or accelerate tasks we would otherwise do ourselves or that help reveal information that we're unable to observe on our own are largely analogous to other tools such as high-throughput screeners, calculators, and microscopes. While generative AI tools like Jaeger may be used to generate new things, generating is not the same as inventing, at least not where it takes a human to define the problem, guide the solution, and recognize, appreciate, and synthesize the results. But that does not fully resolve the matter. A second question, which is top of mind for innovators like us, is whether using AI to assist in R&D compromises the ability of our human scientists to patent the resulting inventions. Here, as a matter of law, we believe the answer is no, but we must ensure that the doctrine of inventorship law known as conception, which traditionally considers whether an invention occurred inside the mind of the inventor, is not applied too rigidly to deprive human inventors of patent rights simply because generative AI now allows some of the inventive process to occur in silico or on a computer. Other principles of existing competition law, such as the ability of an inventor to obtain ideas and materials from others so long as he or she maintains intellectual domination over the process, and the rule that an invention is only conceived when it is operable, recognized, and appreciated can address this concern, provided the Patent Office and courts properly apply them. Because conception law is unique to the United States, though, we believe this is a critical issue to get right so we do not put our nation's innovators at a disadvantage and compromise America's economic and strategic leadership. A third important question is whether we will even need patents if and as AI advances to the point where it's able to fully invent on its own. Here, as a matter of policy, we believe the answer is resoundingly yes, because the patent system's constitutional goal of promoting progress cannot be realized unless innovators are encouraged to not only invent, but to publish, develop, and commercialize their inventions. In this regard, it's important to remember that in our field, the invention of new molecules, proteins, and other substances is only the start of the long, complex, and risky process of developing new medicines. Without patents or comparable incentives to enable that work, we would not have new treatments and cures no matter how many new molecules appear on computer screens. Thank you very much for the opportunity. I look forward to your questions.
Thank you very much, Mr. Salsberg. Ms. Sheridan.
Good afternoon, Chairman Coons, Ranking Member Tillis, and members of the committee. Thank you for the opportunity to appear before you today. My name is Laura Sheridan, and I'm head of patent policy at Google. For more than 20 years, I have witnessed firsthand how patent policy and the law have adapted to match the pace of innovation. Today, I look forward to answering the committee's questions on artificial intelligence and patenting. Google's approach to artificial intelligence is both bold and responsible. We believe we must develop AI in a way that maximizes the positive benefits to society while addressing the challenges. The only way to be truly bold in the long term is to be responsible from the start. We're committed to developing AI technology responsibly, applying strong safety and security practices, and continuing to develop our AI innovations in accordance with best practices. We introduced our AI principles in 2018 to guide our development of this critical technology, and we work closely with external partners to draw on their expertise and share our learnings on responsible AI practices. Google is utilizing AI across our entire business. We use AI in our groundbreaking products used by people everywhere, our contributions to scientific advances that benefit people, and our efforts helping to address societal challenges. The potential of AI to solve big problems is rapidly increasing. We're proud of efforts to partner in the use of this technology to help address problems and improve the lives of people around the world. For example, we're deploying AI to help forecast floods, monitor prenatal health, and detect genetic variations linked to disease. We're also using AI in the innovation process to help expedite chip floor planning, identify optimal neural network architectures, and improve upon the drug design process. These advances are described in greater detail in my written testimony. We have significant experience seeking coverage for AI inventions in the United States and around the world, and have one of the largest portfolios of AI-related patents. And we are engaging extensively with the U.S. Patent and Trademark Office on issues related to inventorship and artificial intelligence, including by submitting comments, offering testimony, and participating in listening sessions. We agree with the USPTO that there is a spectrum of inventive behavior. We believe current industry uses of AI are well within the zone where humans are properly named as inventors and where AI is leveraged as a tool in the invention process. We expect to remain in this zone for some time. However, we do encourage the USPTO to shed light on inventorship, and we believe that guidance from the office would allow for a clearer conversation between patent applicants and their counsel. We also respectfully suggest that the USPTO encourage patent applicants to document inventor contributions. And we encourage the USPTO to implement robust technical training for any patent examiner who is examining AI-related innovations, whether those are inventions on core AI technology or on specific applications of core AI technology. The number of patent examiners who are now examining these AI-related inventions makes up a substantial portion of the examining corps, and that number is only going to increase. We urge that a comprehensive technical training program be put in place so patent examiners are well situated to assess whether or not to grant a patent. Google also supports increases to patent fees for large companies while ensuring that small and micro entity fees remain low. We believe the USPTO will be in the best position to issue robust and reliable patent rights, including in complex emerging technologies like AI, when the fees before the grant of a patent more closely match the costs. We believe large companies like Google should shoulder more burden and support the overall health of the patent system. We appreciate this important discussion on the current state of AI in patenting. Google continues to engage with government officials and the public to further discussions on AI and responsible development principles. Google will continue to provide feedback on the intersection of AI and patents to ensure we continue to strike the right balance for our patent system to incentivize AI innovation. Thank you for the opportunity to appear before you today, and I look forward to your questions.
Thank you, Ms. Sheridan. Professor Abbott.
Thank you, Chairman Coons, Ranking Member Tillis, and members of the committee. A picture's worth 1,000 words, and I've tried to do one better with a 3D printed model of an AI-generated invention. We call this the fractal container because it's a beverage container based on fractal geometry. The United Kingdom Intellectual Property Office, the UK analog of the United States Patent and Trademark Office, conducted a substantive examination on this and determined it was new, inventive, and useful, which are the major requirements to get a patent. The invention came from an AI system called DABUS. DABUS was built and trained by people, but on general knowledge rather than on knowledge specifically about container design. It was not asked to solve a specific problem, and its user had no training in container design or specific intent to design a new container. DABUS was built to combine simple ideas and concepts into more complex ones and identify when a complex concept had a positive outcome. Here, it identified that a beverage container based on fractal geometry would have higher surface area, which would improve heat transfer, like the opposite of a thermos, and it would make it easier to grip. All that before a human being laid eyes on the AI's output. If the AI had been a human being, it would be the patent inventor. When I actually had one 3D printed, I was surprised at how easy it was to grip, which might make it easier for someone with Parkinson's disease to use. I was also surprised to see how difficult it was to drink out of, and it is effectively impossible to clean. But it is an invention rather than a commercial product. And yet, troublingly, the United States has emerged as an international outlier in terms of refusing to provide a patent for this invention. Not because the invention itself isn't deserving of protection, but because of how it was invented. I know that because I have been leading on a pro bono basis a series of legal test cases on the patentability of AI-generated inventions and the copyrightability of AI-generated works, the outcome of which has sadly been to see U.S. courts adopt a strongly anti-patent position. We didn't have a traditional human inventor in our case, so when we filed the applications, which we've now done in 18 jurisdictions, we transparently disclosed it was invented by an AI. Different jurisdictions have very different rules about inventorship. Some jurisdictions don't require inventors to be disclosed. Others allow companies to be inventors, which is not so strange. The U.S. has allowed companies to be authors under the Copyright Act for more than a century. The United States has a strict test for inventorship, the person who conceived of an invention. And usually, an inventor has to sign a declaration under threat of criminal sanctions that they genuinely believe themselves to be an inventor. The Federal Circuit last year held, for the first time in Thaler v. Vidal, that if you don't have that traditional human inventor, you can't get a patent. Of course, no one was ever arguing that the AI would own the patent. Most inventions are not owned by inventors, but rather by their employers. An AI isn't a legal person, it can't own property, and I see no good reason to change the law to allow that. But it is a bedrock principle of property law that you own property made by your property. So if I have a 3D printer make a physical beverage container, I own that. There's no reason why I should be any less entitled to intangible property made by my AI. That's the right outcome as a matter of policy, that the owner of an AI system should own inventions made by that system, because the system is designed to provide incentives regardless of how inventions are made. Allowing this to be patented will provide encouragement to the use and development of inventive AI that will generate more socially valuable inventions. It will encourage the owners of these systems to disclose inventions rather than keep them as trade secrets, and it will encourage the investment needed to commercialize inventions. So what should Congress do? Amend the Patent Act to allow the protection of AI-generated inventions by prohibiting patentability from being based on how an invention is made. Designation of inventorship is less important than patentability, but it would be best to keep legal inventorship based on factual inventorship. In other words, where an AI has invented something, it should be disclosed that it is AI generated. This will tell the public how it is made, it will facilitate ownership determinations, and it will keep people from claiming credit for work done by AI. That's not unfair to AI, which has no self-interest, but it's unfair to other inventors displaying legitimate ingenuity and by equating their work to someone just asking an AI to solve a problem. Protecting AI-generated inventions and AI inventorship is a simple, common-sense solution that will not cause other complications. And it is critical for Congress to act on this now, not just because of the state of AI today, but because investments need to be made now in the AI and innovation of tomorrow. And there is a universal consensus that AI is only going to get better at doing this sort of thing. If the right frameworks are in place, the outcome of that should be significant benefits for everyone. Thank you.
Thank you, Professor Abbott. Professor Villasenor.
Chair Coons, Ranking Member Tillis, members of the subcommittee, thank you for the opportunity to testify at today's hearing. I'm testifying today on my own behalf and not on behalf of any institution. When discussing the intersection of AI and patents, it's helpful to identify three categories. First, there can be patents about AI. Second, there can be patents describing inventions created using AI. And third, AI can be used to write patent applications or public disclosures intended to serve as prior art. Regarding patents about AI, my point is simple. The U.S. Patent and Trademark Office is well equipped to handle patent applications for inventions about AI and has been doing so for years. Now, the second category, inventions made using AI, poses a complex set of policy questions. First, should AI inventions be patentable? Second, how should inventorship be handled? I believe that AI inventions should be patentable and that inventorship should be attributed to the natural persons who use AI as a tool to enhance their ability to innovate. More specifically, as I explained in a recent law review publication in the Santa Clara High Technology Law Journal, conception should encompass ideas formed through collaboration between a person and tools that act as extensions of their mind. To operationalize this approach, I believe that no statutory changes are needed. I believe that this view of conception is consistent with current U.S. patent law. Some people propose that AI systems should be named inventors. I respectfully disagree. First of all, as we know from the Fowler litigation, this would require a change to U.S. patent law. Many members of Congress would be rightly concerned about the consequences of that change. There are other problems as well that would arise if that change were made. An AI system cannot provide the required inventor's oath or declaration that must accompany a utility patent application. An AI system cannot get deposed in litigation regarding an invention. It can't give sworn testimony. Another approach that has been proposed is to deem AI inventions wholly unpatentable. I do not support this approach. It would disincentivize investment in the use of AI in areas where it has high potential. For instance, a pharmaceutical company would be unlikely to make significant investments in AI-assisted drug development if it expected that any resulting drugs would be deemed unpatentable. It would create a new category of patent ineligibility based on having used too much AI when making an invention. The resulting how much is too much question would generate years of confusion and litigation. The third and final category is the use of AI to write patent applications or preemptive prior art, publications designed to foreclose patentability. Let me emphasize here that the use of AI writing tools to help create explanatory text or figures regarding inventions is not inherently problematic. It is reasonable for an inventor to use AI as a time-saving tool for describing an invention. However, a problem arises when AI is used to describe alleged inventions for which there is no conception by a human. Computer algorithms, whether or not AI-enabled, can be used to write and publish large online disclosure databases intended to foreclose patentability. This idea is not new. There is at least one website in this category that has been online for multiple years. To the extent that such publications occur without any substantive nexus to human understanding of their contents, there is a good argument that they should not count as printed publications under 35 U.S.C. 102A. The entire concept of prior art is tied to what a person of ordinary skill in the art would know. The person of ordinary skill is a hypothetical person who is presumed to know all prior art in the relevant field at the relevant time. But I do not believe that a person of ordinary skill's knowledge should be so broad as to include purported art embedded in computer-generated text for which there is no evidence that any human has ever understood the significance. In closing, I will emphasize that AI has extraordinary promise. In the mid-21st century, maintaining U.S. global economic competitiveness will require that the United States be a leader in AI innovation. A patent system that incentivizes the use of AI to innovate is a key component of that leadership. Thank you, and I look forward to your questions.
Thank you, Professor. Last but not least, certainly, Ms. Elluru.
Chairman Coons, Ranking Member Tillis, and members of the committee, thank you for the honor to testify today. I'm here to discuss the implications of artificial intelligence on our intellectual property regime. Specifically, I want to share the IP recommendations from the final report of the National Security Commission on AI, the independent commission Congress created to provide recommendations for advancing the development of AI to further U.S. national security needs. The United States is in a global technology competition. The Chinese Communist Party understands that the way to achieve dominance is through supremacy in key emerging technologies. AI is at the center of this competition. I emphasize that AI is a foundational technology. AI will influence nearly every aspect of our lives, especially as generative AI becomes ubiquitous. AI is a technology like electricity upon which other technologies are built. AI, in combination with other technologies like faster semiconductors and biotechnology, will only accelerate our discoveries. We are in a race to develop the future of AI, a race we are in with China. This innovation competition will shape the world's future. The nations that hold the leadership and dominant market share in the combination of emerging technologies will be able to reinforce their societies and their economies, and importantly, assert geopolitical influence. Which nations and how these nations shape the development and adoption of these technologies will determine the geopolitical order. The United States must lead in the tech competition because at stake is a values competition. We want these technologies to be developed and used according to our standards and norms, which is the opposite of how China is using this innovation, such as surveillance of its citizens and oppression of minority groups. And we cannot do it alone. The United States, along with our many close partners and allies, must maintain our technology lead over China. So how does the United States retain its global tech leadership? We leverage the strength that has allowed the United States to outpace and outmatch every technology challenger we have faced over the past century. Our strength and power is American innovation. Intellectual property rights have historically been a critical lever in ensuring America's innovation leadership. America's IP regime has spurred American ingenuity since the 18th century with the 1790 Patent Act. The last major overhaul of the patent system was in the early 1950s, right before the field of AI emerged in 1956. Patents are property rights that incentivize new ideas and inventions by rewarding inventors for sharing valuable information with the public domain. These incentives are especially important now when the majority of funding and tech development in the United States is from the private sector. The NSCAI addressed the asymmetry in U.S. and PRC IP strategies in Chapter 12 of its final report. What can the United States do in practical terms to implement patent policies that promote AI innovation? First, the United States must recognize IP policy as a national priority and require the development of a comprehensive plan to reform and create IP policies that further our technology competitiveness goals. Second, we need an entity with IP expertise that can coordinate the various IP equities across our government to develop and propose IP policies on an ongoing basis. Third, the United States must elevate and coordinate technology policy in the White House by empowering a single entity to implement a comprehensive technology strategy, a strategy that integrates IP proposals. Lastly, we must prioritize IP considerations that need to be assessed. The NSCAI proposed a non-exhaustive list of 10 IP considerations, which are included in my written testimony. Lastly, at the Special Competitive Studies Project, we are exploring a number of these considerations in partnership with the Renewing American Innovation Project at CSIS, which is headed by former USPTO Director Andre Iancu. I'm happy to go into any of these topics during our discussion. Thank you again for the opportunity to be here today.
Thank you, Ms. Elluru. We'll now begin a 5-minute round of questions for the members of the panel who are here, members of the committee, to ask members of the panel. If I might, Mr. Salsberg, just to open, can Could you speak a little bit more about the difference between non-generative AI and generative AI in the biotech field, and why generative AI may raise patent law issues that other AI doesn't? In the example you gave of developing new molecules that might be useful in the fight against malaria, you referenced Jaeger. Why is Jaeger not an inventor in the example you gave when it was generating novel virtual molecules? And why are the human scientists the inventors and the AI simply a tool?
Yeah, thank you for the question, Senator. So at all AI today, at least at Novartis, and I cannot speak for other fields, but are tools that are trained on data to basically recognize patterns and apply them in new ways, either to existing data in the case of non-generative AI, so it's learning a pattern, then looking at our data such as our compound library or data from past clinical trials or images of cells after different experiments and trying to find a similar pattern there. That we call non-generative because, as the name implies, nothing new. Generative AI is basically doing the same thing. It is being taught a pattern. It's being taught to recognize it, but it's applying that pattern then to create something new, or generate, I should say, is a better word, something new. In the case of Jaeger, I think the reason why this raises concerns is because of the confusion between generation on the one hand and invention on the other. We would say they're not the same because Jaeger, at least in our example, is not an inventor because both factually and legally what it's doing is not equivalent to human inventorship. It neither identified a problem, at least in our case. In our case, the problem is malaria, right? It was to design new malaria drugs. It didn't know that there was malaria out there. It was told, do a drug that does this. It didn't consider how to address the problem. It had to be seeded with taught first with 20,000 examples of compounds, then seeded with 3 lead compounds that we know have antimalarial properties to teach it how to design a molecule. After that, the key point, I think, between invention and non-invention is an area of the law called it's recognition and appreciation. That is part and parcel of conception, and also just factually from common sense, we know that to be conscious, we have to recognize what's going on. We don't believe that at this point in time, even generative AI is recognizing anything that it is doing. Last point I'll make really quick. I know I'm short on time for your questions, but a lot has to be done after these molecules appear on a computer screen. They need to be validated. They need to be synthesized, which is actually not obvious or easy to do.
Understood.
So.
Thank you, Ms. Sheridan. Can you imagine a time in the relatively near future when AI will advance such that it really is possible for AI to generate meaningful inventions with no human intervention at all?
Thank you for the question, Senator. You know, it's in our written testimony that our current experience and what we expect to be the experience for, the foreseeable future is no. The human involvement is so great at this point when AI is being used as a tool in the innovation process from start to finish.
You mentioned guidance from the PTO and inventorship would be really helpful. You expounded on that just a little bit. Is there anything you missed that you think we should hear about what that guidance from the Patent and Trademark Office should look like as we move forward in examining this intersection between patent law and AI?
I would have it really look at 2 big things. One, it should be broader than AI. I think AI is creating this conversation, but I think inventorship is challenging. So I think that guidance should more broadly encompass, AI usage, but also other tools. There are computer simulations. There are other things that are being used in the innovation process. And I think, 2, it really should give comfort to inventors that they are doing their best to memorialize the inventorship for their patent applications and, taking a position from the PTO in terms of what we're talking about with joint inventorship, that the humans are properly named.
Professor Abbott, you mentioned you've letter managed, I think it's 18 now, foreign patent cases involving Dr. Thaler's AI-generated inventions. And you called the United States an outlier in failing to recognize inventions that are AI-generated for patent protection. What are the consequences of that? What do you see as the costs or the risks to the U.S. system? And you asserted that it wouldn't cause any other complications for us to modify patent law in a way that allows essentially co-invention. I'd be interested in whether other members of the panel agree, and if you'd address my question about what are the consequences of our being an outlier.
Sure. Well, I think the most pressing commercial problem here is not where you have co-invention, although that can sometimes be an issue, but where you don't have a traditional human inventor you could identify. And I agree in Mr. Salsberg example, you have that or a good argument for it, where you do have a lot of human intervention. And there's always human intervention, right? The question is under inventorship law. There's a thing that someone does that makes them an inventor, And sometimes that thing is now being done by a machine. And perhaps not that much right now, but it is increasingly going to be the case that AI is doing this, that companies like Microsoft are pre-training these drug-seeking AIs on how to generate new molecules and how to validate them. You can have AI that will evaluate the utility of its own output. When you are, for example, modeling industrial components and you know, I want an industrial component that is lighter or that is longer or that meets some preset criteria that's well understood in the art. So as AI...
So in your instance, was it simply a failure to instruct that the container should be easily cleanable?
Well, if someone was now making, one can get a lot of patents on a single product, right? So it might be that this was the first product. Someone uses that and says, you know what? This is great, but I need it to also be cleanable. So how can we redesign it for that? And if a person did that, they might be an inventor on that second patent. But basically, it's all a question of degree and what specific input a person has into invention. But
what are the consequences of our being an outlier?
The consequences are that companies will be discouraged to use AI in the invention process because it will risk them getting patents on their inventions, right? And that will depend very much on the field in which AI is being used, the systems being used, and the specific facts of how this is done.
Thank you. I have a lot more questions for the panel, but respecting that I'm already over time, I'll yield to my ranking member.
I think I would have started by asking AI how I could develop an accessory that I could pay for, that I could sell after I sell the bottle that cleans it very well. I'm sure somebody's probably already working on that. Ms. Elluru, you, did I pronounce that right? Tell me a little bit about your current assessment of, you in your opening comments were talking about really Western world versus China in this competition. Where are we now in terms of the pacing threat of China surpassing us, or have they?
I think the U.S. is in the lead with respect to AI, but barely. The U.S. is leading in cutting-edge chip design, but manufacturing of semiconductors is still a contested space with Taiwan at the center. I think the U.S. is forefront in novel algorithms and architecture, and it has the frontier large language models. But China is leading in data, in part due to its pervasive domestic governance and collection regime. I think with respect to large language models, it is a little bit hindered because these large language models are trained on the Internet, and the Internet is mostly in English. They also have censorship, which constrains their access to data.
You also mentioned in your opening testimony, you didn't use these words, but I inferred from it that you feel like the administration needs a kind of whole of government view with respect to AI. But would you elaborate on that? What would that look like?
I think, as we recommended at the NSCAI, that we need a single entity with IP expertise that can coordinate and, importantly, unify the different IP equities across the government. And we recommended that sit with the United States PTO director as well as the Department of Commerce secretary, and that other federal government agencies and departments resource efforts and to resource their efforts to support this PTO director.
Mr. Salsberg, you mentioned in your testimony clarifying the law surrounding conception would restore certainty. Can you state that if too narrowly construed, the law could potentially be misapplied to deprive human inventors of legitimate patent rights to their own inventions?
Yes, we do believe that if it's too rigidly applied, that could be the result, because we have a standard that has been established in a different context. It was about priority of inventorship, meaning which of two inventors invented first. For 100 years, we've had a law developed that looks at what happens in the mind of the inventor. And we believe that that is way too rigid of a standard, but we also think that existing law has multiple principles available. I know I'll be very brief in my answer, but there's a case called Morse versus Porter, which says that as long as an inventor has intellectual domination over the process, you can even adopt key ideas from outside. And also, if you don't recognize, appreciate, and have an operable invention at the time that it is created, it is not actually conceived until someone else recognizes and appreciates it. So we think combining these doctrines together, and there's a bunch of cases in our written testimony that stand for these propositions, if the courts and patent office apply this properly, we can resolve that issue under existing law.
Just briefly, can you explain how we compare to other countries, other jurisdictions?
Yes, we're the only country in the world, to the best of my knowledge, that has anything like a conception requirement. In much of the world, you never even get asked about inventorship. Many countries, you list an inventor and it's just of your own accord. It only comes up in situations where a remuneration dispute or a joint inventorship dispute comes up. Some countries don't even require you to list an inventor, like Israel and Austria.
The final question, I may also stick around and ask some further, or not a question, but it feels like to me, in everything that we do on Capitol Hill, we're doing well when we're providing certainty in various areas. And I feel like if we don't tackle these IP issues, that we are likely to be the jurisdiction where these inventions occur. Would anybody disagree with that? That there is work that we have to do. There are some that are saying it can work within the current law, but I, for one, feel like we have to have certainty and clarity, or we really run the risk of having the gap. Maybe our competitive advantage today will not be the same just a few short years from now, given the pace, the rate of change that we're observing in AI space. Does anybody disagree with that? That it's not broke, don't fix it. We've got something we got to work on here. John or Villasenor?
Well, as I've argued in the law review article I mentioned and in the testimony, I think U.S. patent law already accommodates AI inventions, and that the inventor should be the human who uses the AI as a tool, as an extension of their mind. I think that's consistent with the understanding of conception that's been in place since conception is not defined in Title 35. It's actually comes from a 1890 treatise by Robinson, and the Federal Circuit has cited that as recently as, I believe, 2021. And I think just viewing the conception through that broader lens, consistent with that original commonly cited definition, is enough to encompass and take account of inventions made using AI.
Yeah, I think my concern is if we don't identify some of the bigger threats here and provide clarity, this could be sorted out in the courts, which is one of the reasons why we're working on patent reform, because we have a lot of really bad decisions that came out of the courts with people who really didn't understand the underlying concepts of the case they were overseeing. Thank you, Mr. Chair.
Thank you, Senator Tillis. Senator Hirono.
Thank you, Mr. Chairman. So the thing with AI is that it is being developed. The use of AI through in so many different ways is happening by leaps and bounds. And as we sit here struggling to figure out a way to regulate AI in an appropriate way without really discouraging invention, et cetera, it's not the easiest thing to try to decide what to do. And in fact, none of you mentioned for example, the White House blueprint for an AI Bill of Rights and the Bill of Rights that individuals should have. And as we sit here knowing that some entity out there can replicate our voices, put out a campaign ad that we've had nothing to do with, and what are we supposed to do about that? We have no awareness of it. We don't even know this was an AI-generated thing. So the implications are vast on how we should be regulating AI. We just know we should. Can't decide what to do quite yet. But it's interesting to hear your testimony about what should be patentable. And after the Thaler decision, where it seems very clear that the human element has to be there in order for something to be patented, except I believe Mr. Abbott, your approach seems to be so simple. Whoever owns the AI system should own whatever is invented through that system. I'd like to know from the rest of the panelists whether that is the way we should go in spite of the Thaler decision. Let's start with you, Mr. Salsberg.
Thank you for the question, Senator. That is one option if and when we get to the point where AI is truly inventing. As I said in my testimony, we're not sure we're there yet. But if and when we get there, we totally...
Well, things are moving so fast that I can envision that we're going to get there.
And when we get there, we're in full agreement that we do need to make sure that patents still issue to those who use AI to create useful inventions for society and promoting progress. We think there are three ways to address it, though. One is to award a patent to AI. Another is to simply change our inventorship standards and expand what it means to invent. And we believe, again, we can get there by taking existing principles of conception law and applying them properly. And if that doesn't work, we also think we can eliminate the inventorship requirement in most situations and get to the same result without having impact on other aspects of patent law, such as the level of ordinary skill in the art of an AI and the inventor's oath and things like that.
Ms. Sheridan?
Thank you for the question. I agree with Mr. Salsberg. Our current experience is the human is very much involved. The human is the inventor. I have kind of two concerns with the approach of, going with, the system being an inventor or the ownership vesting in the owner of the system. I think one just sort of sits with the Constitution and the reason for the patent system, which is to incentivize the behavior of humans to innovate. And, I question whether that incentive is needed for an AI system. I think that's not really the purpose of the patent system in the first place. So I would want to, think more about, does that line up with the purpose of the system? I think the other question, though, which is more the one that would keep me up at night, is obviousness. Inventions need to be non-obvious. And if you have this ability for an AI to be named, what does that mean for the obviousness test? Where is the bar, and who are you kind of measuring this against? And how does a patent examiner, one of 8,000 in the PTO's workforce, apply that? So I think there are a lot of open questions that would come up from what seems to be a simple fix.
I'm going to move on to Mr. Villasenor.
I just very briefly, I'll just say that everything an AI system does is ultimately traceable back to one or more people. And I think that when we focus only on the AI system, we miss potentially the incredibly important and relevant in this context contributions of the people who have ultimately enabled an AI system to do what it does.
So you're not particularly troubled by the idea that whoever owns the system should own whatever the system generates?
Well, actually, I am in the sense that I think the owner, whoever owns the system shouldn't be the dispositive question. Again, I believe that the people who use AI as extensions of their mind should be the inventors, and that would be true even if they, for example, leased under a contract an AI system that they use to expand their creative capacities.
Mr. Chairman, could I ask Ms. Elluru to?
Thank you, Senator. I have two comments to make, and the first one is open source. If we recognize patent owners as having the right, as what happens when a user uses open source models to invent? And the second comment is with respect to obviousness. I think that AI is going to be commonly used in the invention creation process. So I think we will have the obviousness issue regardless of whether we recognize AI as an inventor or not.
Thank you, Mr. Chairman.
Thank you, Senator Hirono. Senator Blackburn.
Thank you, Mr. Chairman. Thank you to each of you for being here and for your testimony. And I so appreciate that we are looking at this issue. I'm from Tennessee. We have a lot of entertainers. The voice cloning is an issue. ChatGPT, being able to write a song that sounds like it would be in the style of so-and-so, some artist, that's an issue. And making certain that we're able to preserve these intellectual property rights is, this is coming up a lot as we talk with our entertainment community. So, and then also we have a lot of people that are doing work in the energy space, automobile manufacturers. And they're busy. Ford has done a huge investment in Tennessee with SK batteries, billions of dollars there. GM has its Ultium battery facility in Tennessee. Now, these innovators are saying, I want to hold my invention. And, of course, China, which we've discussed some today, is a pro at lifting intellectual property and not protecting that intellectual property. And I look at what they're doing, stealing it, our intellectual property, the emergence of China, and their aggressiveness in the field of AI. And Ms. Elluru, I want to come to you on this. I pulled a number, 2021. China was the global leader for patent filings. and they had 1.59 million filings. They were double us. Then 2011 to 2021, Chinese AI-related patents accounted for nearly 75% of the global total. That should be a wake-up call to every one of us, especially those of us that represent so many innovators. And I decided to go on and look at what was happening with PTAB, because so many of our innovators have their patents challenged. And China has been very aggressive using this, and primarily ZTE and Huawei are the companies that are the leaders, if you will, in challenging U.S. patents. So, Ms. Elluru, as we look at this and we look at the global marketplace, I want you to go a little bit further than you did in your response with Senator Tillis and talk for a minute about that threat that is there with China trying to dominate in this space to the point that they've doubled our number of filings. They are, they've got 75% of that global share, and then they're coming at it from the other angle, trying to discredit our patents.
Thank you, Senator, for that question. I think with respect to China's prolific patent filing, quantity does not always equate with quality. However, there are implications with those numbers. First, they're using it as a narrative that they're winning the tech competition.
Well, and that they're kind of blocking competitors, correct?
Absolutely.
Okay.
And so I think there's a real parties and interest issue, too, with China using our system against us.
I agree with that, and I think it's why we have got to push back on that narrative because of the numbers and the way they're trying to be the first to file in certain areas.
Agreed.
Yeah, I have quite a few concerns about that. And what they're going to do with really pushing through on this system and using the system of protection we have to advantage themselves. I do want to move to one other thing. I'd like for you to speak for just a minute about what we do to counter this aggressiveness. As you look at it, what steps would you say we need to take? And anybody else, after Ms. Elluru weighs in on this, anybody else that has a suggestion, I'd love to hear that.
Thank you, Senator. I think the first thing we need to do is recognize IP policy as a national security priority across our departments and agencies. And as I mentioned earlier, we need a central entity with IP expertise that can coordinate across the government.
Okay. Anyone else? Anything to add?
Yes, thank you, Senator.
Salsberg.
I would just quickly add that we should fix patent eligibility under Section 101 for both software and diagnostics. And two, we should clarify conception law if the courts, and this body should do it if the courts and the Patent Office don't apply it properly to make sure that the use of AI is encouraged and adopted by American innovators.
Okay. Anything else from any of you? No. Thank you, Mr. Chairman.
Thank you, Senator Blackburn. Senator Padilla.
Let me begin by just thanking you, Mr. Chair, for holding this hearing, and a special welcome to the majority of the witness panel that are Californians. Not a coincidence. Certainly a timely topic, since our innovation ecosystem should be a prominent element of our ongoing AI development and regulatory discussions taking place here in Congress and within the administration. And our patent laws obviously play a significant and vital role in shaping that ecosystem. And I know there's growing anxiety about AI systems and tools potential to replace or displace the work being done by humans. And the questions raised today about how much invention needs to come from humans to preserve intellectual property rights mirrors actually the some of the discussion taking place in the world of copyright law. So I want to take time right now to ask about how AI is impacting human invention and innovation. And I want to help us focus that discussion, cite Stanford's AI Index 2023 annual report. Quote, AI models are starting to rapidly accelerate scientific progress, and in 2022 were used to aid hydrogen fusion, improve the efficiency of matrix manipulation, and generate new antibodies. So clearly, AI has been and should continue to be a great tool for invention and discovery. I know I've said a lot. That's just to tee up the following question. I'll address it to Ms. Sheridan. Can you speak to the way AI is helping not just your company, but the industry invent? And under current U.S. patent laws, you understand it, how does the use of AI affect the ability of your respective industries to patent those inventions?
Thank you for the question. So, I mean, in our observations and use of AI, it's really been a powerful tool in the inventing process. We create, machine learning models, and then we're able to use those models in further development, whether it's for chip floor planning or neural network architecture search. So it's been an incredibly important tool to us. I think there's two topics here. One is the use of AI as a tool for innovation, and then there's simply the topic of AI innovation in general and making sure that the system is both balanced to encourage both of those things. And the conversation we're having around inventorship, that really relates to this question of using AI as a tool in the innovation process. And the conversation we have just around the general patent system and making sure it's striking the right balance, that's for innovation writ large. And I think there's a statistic from an IEEE report that shows, 70% of all AI patents are held by U.S. companies as of 2018. And I think that really shows, right now in the U.S., innovation in AI is growing, it is flourishing, and we have patenting activity that reflects that, both in the core AI innovations, but also in the use of AI as a tool to innovate.
Thank you. Clearly, much to continue to discuss on that point. But I also want to make sure I talk about the innovation trends that we're seeing. AI innovation has grown at a rapid pace. We all acknowledge that. And the use of AI by innovators, as Ms. Sheridan just referenced, whether it's individuals to startups to large enterprises, is also growing rapidly. One study found that AI will potentially contribute $15.7 trillion to the global economy by 2030. Now, the Patent Office has found that the volume and the share of public U.S. AI inventions has grown significantly in the last decade alone. More than 15% of all published patent applications in 2020 were directed to AI technologies, equivalent to almost 80,000 patent applications, just to give you a flavor for the volume here. And there's been a tremendous investment, obviously, in artificial intelligence R&D among U.S. companies. Question for Ms. Elluru and Ms. Sheridan. Do you believe our current innovation ecosystem, including our patent laws, are incentivizing AI-related innovation, or how else would we interpret the increase in AI patent applications?
Thank you, Senator, for that question. I think there's a lot of uncertainty in our patent laws currently with respect to patent eligibility, also with respect to whether AI-generated inventions are patentable. I think that the common view right now is that AI is a tool, a very sophisticated tool that's used in the invention creation process. I think some people would say that you still need an inventor to frame the problem set, analyze the output of the AI, recognize and appreciate the results. But I think an argument can also be made, especially in litigation, that the AI is contributing to the conception process itself. It's augmenting or supplanting cognitive capabilities. And under current law, an AI machine cannot be an inventor, so the argument would be that the AI machine was a co-inventor but cannot be an inventor, so under current laws, that's unpatentable. And I think that uncertainty leaves to unpredictability, and it diminishes the patent system. Thank you.
Ms. Sheridan.
Thank you for the question. We have seen AI innovation flourishing, and I think the patent numbers are one thing that reflects that. There are other ways we see it in the investment you mentioned, the growth of the economy. But it's really important, and I mentioned this in my opening statement, that training is in place for examiners, because you mentioned a statistic about the growth in AI patenting at the office. That means, at some point, the majority of patent examiners are going to get an invention that crosses their desk that relates to AI in some way. And they may not be experts in AI, they're experts in the field that AI is being applied. And it is critically important to make sure that examiner knows what they're looking at and knows, yes, this is a deserving patent, I can grant this, or no, this is an obviousness issue, or whatever it might be. Training is really just a fundamental issue that to continue to incentivize this level of innovation, which we already have, we need to make sure that PTO examiners are given the tools that they need.
Thank you. And last, just a comment to Professor Abbott. Please don't show that cup to my kids, because no doubt they're going to want to put their fruit smoothies in there, and then I'm going to have to be stuck scrubbing it out.
Well,
thank you, Mr. Chair.
Senator, very briefly, on behalf of the California academic contingent, thank you for having us and for not inviting anyone from USC.
Thank you. Thank you, Senator Padilla. Senator Blumenthal.
Not going there. But I am going to make a very non-scientific observation here, at great risk, I must say, because it could lead to unwarranted conclusions. But I would say, looking at the audience in this room and the group waiting outside to get into the room, that the average age of our audience is roughly 1/2 the average age of United States senators.
Senator Blumenthal, we confirmed that. I had a show of hands. There's only one in the audience who's over the age of 35.
Which is enormously exciting for me. And I make this statement not out of any ageism, but I guarantee that in China or in many of the other countries that are potential competitors, there are not groups like this one voluntarily pursuing research, innovation, invention in this area and coming all the way from other parts of the country to listen to this kind of proceeding. So I want to thank you all for being here today. And when I thank you, I'm thanking literally thousands, tens of thousands, hundreds of thousands of young people who are studying this area and who will be the source of invention. And you're right, Ms. Sheridan, AI invention and innovation are flourishing in this country, which should be a source of pride and excitement to my colleagues and myself, which brings me to my first question. A number of experts in the industry have suggested we ought to have some kind of pause on innovation or on the release of new products, put aside the issue of testing them. Even if I thought it were a good idea, I don't. I think the idea of a pause is totally impractical. So let me ask any of you whether you think a pause on AI, I know it's a somewhat simplistic question, is a good idea and even doable.
Well, just to briefly address that, although I think you addressed it yourself a bit, I think the biggest reason a pause would be bad, as Senator Tillis mentioned, is a lot of social good is going to come out of AI, and with the right frameworks in place, predominantly good rather than risk. And pausing it means that we're not going to get this innovation and creativity and value from AI that we otherwise get. On top of which, I don't think you really could enforce a pause. And on top of that, other jurisdictions are not going to similarly pause. So
well, that's my next, unless anybody disagrees, just in the interest of time, I'm going to move to my next question. Yes, sir.
Well, I was just going to say I agree that it would be a bad idea for many of the same reasons. Totally unenforceable. Yeah, I could list lots of reasons why it's a bad idea. I don't support the idea of a pause.
And the ones who would love it the most are the Chinese, our competitors in other jurisdictions, as you've said, Mr. Abbott. So it's a bad idea for a lot of reasons, and it's impractical and unenforceable. I want to ask a question because you mentioned the word framework, Mr. Abbott. And in a hearing that Senator Hawley and I had in a different subcommittee of the Judiciary Committee, the Privacy and Tech Committee, we focused a lot on this idea of a new agency licensing and registration, guardrails and safeguards like maybe what I called a nutrition label, means of distinguishing and stopping deep fakes, audio clones, and so forth. Some of the bad outcomes of AI innovation. I have in mind a framework, probably a new agency, that would not in any way impinge on the current patent system. Do you think that kind of new agency is compatible with our current intellectual property protection system? I'm going to open it to anyone who wants to respond.
Thank you for that question, Senator. I think that we need to use existing regulators to adopt AI regulation with existing authorities as in the short and medium term, but I think also exploring the new agency and new AI agency and its functions is a great idea. I think it'll take time, so I don't think those two recommendations are mutually exclusive, and I think we need to pursue both at the same time.
I'll just say I think it's important to recognize the protections we already have under broader existing frameworks. For example, if a company uses an AI system to make hiring decisions in a manner that discriminates based on a protected characteristic, that would already be unlawful under Title VII of the Civil Rights Act of 1964. So we already have a lot of frameworks that would apply to AI, even though they are not AI specific.
Mr. Abbott.
Just to briefly weigh in on that, I mean, I think you are completely correct that it is the government's responsibility at some level to manage some of these risks for the public, and that having an administrative agency dedicated to that would be helpful. I do think that as a general matter, a technologically neutral approach to the issue is the right way to go. So, for example, if we want to, and we do, prohibit discrimination based on protected characteristics, that there are laws that apply to companies doing that, whether you have a human resource manager or an AI system operating to do that sort of thing. So I think in principle, it's a good idea, but very much depends on the details of how it's implemented.
Thank you. Ms. Sheridan or Mr. Salsberg, do you have observations? I'm going a little bit over my time.
Sure. I would agree with the other speakers. I would just add that it's also important that we make sure that there's public sector and private sector collaboration in forming this kind of commission, or at least into the input. Because we also want to make sure that we're not undermining innovation. And I would also add just one more point, which is that there are other agencies like FDA in the case of our industry that are already looking at these issues, and it's very important that they continue to be a part of this. One statistic is that over 100 applications to FDA in 2021 have already contained AI or machine learning components. So they're already looking to these issues, and if we had a new commission, we'd have to make sure there's coordination between those agencies.
Thank you. I'll keep it very briefly. So our CEO has said AI is too important not to regulate, and it's too important not to regulate well. I think our view of regulation is a sectoral approach is appropriate, and when it comes to patents, that would mean the Patent Office kind of handles issues related to patent policy. But we do believe, it's regulation is important.
I welcome all of these comments, and this hearing and the one that my subcommittee did, I regard as just the beginning, and I hope that we can call on all 5 of you and many others to be involved, because we do, to take Mr. Salsberg's point, want to regulate. I think everyone has agreed regulation is necessary, maybe through some kind of federal agency, call it an administrative agency, but we also want to continue to encourage innovation, and the startups and the folks who are in this room who are going to be inventing stuff in their parents' garages, not to deprecate anybody who's in this room, but as you know, that is a well-founded source of innovation in this country, and we want to make sure that we don't heavy-handedly deprecate or discourage innovation. Thanks, Mr. Chairman.
Thank you, Senator Blumenthal. Before I defer to Senator Tillis to begin a second round, I just want to follow up on that point, if I could, because one of my concerns about how we regulate AI is that we may end up favoring well-funded and established companies and make it dramatically more difficult for the startup, the innovator, the category breaker, smaller companies that are the backbone often of American innovation to compete. I'd be interested in any brief comments from the panel on how you think we strike that balance. How do we regulate AI responsibly without hampering innovation? Ms. Elluru, do you want to begin? And I'll just welcome any brief comments from members of the panel.
Thank you, Senator. I think we do so very carefully. One of the things that we've recommended at the Special Competitive Studies Project is that we focus our governance efforts on high consequence use cases. To going to Senator Tillis's comments earlier, AI can have benefits as well as harms, and we need to focus our efforts on those benefits and harms that are going to have the most significant impacts in societies and individuals. So it is a risk-based approach, and we need an American model of identifying what high consequence use cases look like.
I'll just say that, as we all know, new market entrants, new companies have been the source of an incredibly large amount of innovation historically in the technology space in the United States, and there's no reason to believe that's going to change at all in the sense of AI. And given that, it would be a mistake to implement a regulatory regime that, as the Senator, as you said, favors the large, well-funded incumbents who have the resources to comply with very burdensome regulation while disfavoring the new market entrants who are going to be the future Googles of the world.
Thank you, Professor Evan.
I might make a broader point, which is that I think when confronted by this technological evolution and how it's challenging current laws, that you should take a step back and think, what is the purpose of patent law and what is it that we want to do? Right? Someone earlier said, well, it's to benefit inventors. In copyright law, for example, despite the copyright clause of the Constitution, the U.S. Supreme Court has held copyright law is not primarily to benefit authors. It's primarily to benefit the American public by encouraging the creation and dissemination of new works. So do we want a patent law that is going to specifically encourage human behavior and discourage people automating? Do we want something that's going to benefit small companies more than bigger ones? Or do we want something that's just going to generate more public good and more innovation? I think the right place is for Congress to decide what the goals of the system are, and then, implementing it follows from that.
Yes, the point that Professor Villasenor just made was historically across technology broadly, if you come up with a system that disfavors the innovator, the small, the startup, then you will, as a consequence, have less innovation. Would you disagree with that as a general?
No, I agree with that. And I took his point also to be, the more regulatory requirements you place, it tends to be more burdensome on small and medium enterprises than companies like Novartis and Google that have large teams of people that can help comply with this sort of thing. So, that sort of approach, I think, is more warranted the higher risk use you're looking at.
Thank you. Ms. Sheridan.
Yeah, to bring this into a patent context, I think I'd support something as simple as fee increases. And I mentioned that in my opening statement, but I think if you want to make sure that small and micro entities before the Patent Office have a robust examination when they have that AI innovation before an examiner, you need to make sure the office has enough fees to do that examination. And large companies like Google can support that and make sure that the resources available to the Patent Office are greater up front.
And, of course, we need to permanently end the pernicious practice of fee diversion.
We would agree that that would certainly be a good thing to do.
One of my goals in getting elected to the Senate, literally. Mr. Salsberg.
Yes, thank you. I would just echo the importance of following a fact-based and a risk-based approach to this to strike the right balance, and also the importance of involving the different entities within the private sector in that conversation. I think it's critically important. Last point I'd make is the risk-based approach is roughly what I believe the European Commission is following in its proposed AI. It's the AI Act. It's not a perfect act, but that is the general approach. And I do think it needs to be tailored to the specific risks identified in each application of AI.
Thank you. Senator Tillis.
I'm just imagining the scene of where you're on the stump campaigning for the Senate, the applause line when you talk about ending fee diversion. I'm sure that's a crowd pleaser.
They probably applaud the diversion.
But, back to Senator Blumenthal, he looked at the crowd much the way I did, and it's good news to see young people focused on this subject. I think one thing we have to do here is educate the members of Congress well in advance of baking any policies that could have a significant impact on regulatory burden or regulatory certainty. And I am pleased to hear, I think, that the House, the Speaker, has actually had a course curriculum put together by an East Coast institution to educate our members on AI policy implications. And I think also quantum computing. I'm going to reach out and see if that's something that we can get here. I'm actually going to another meeting here on AI with Senator Warner shortly, and one of the subjects that we're talking about are the possible results from improperly developed and secured models. We haven't talked about this here, but that's another thing that we can't assume that all AI engines are equal. All of them are fully vetted. All of them are safe. I mean, that's a completely different outside of the jurisdiction of Judiciary Committee, but something we have to look at and get a light touch, but start recognizing those outcomes. Ms. Sheridan, I should have mentioned to you, I mentioned that I'm in the ChatGPT beta program, but I have also explored Google's offerings, Microsoft's adaptation of ChatGPT, and the dozens of other engines that are out there. One of the things I'm trying to wrap my head around, and honestly, it came to me as I heard you all talking, is explain to me how I'm in the group of let all inventors invent. I don't care how big you are. I don't care what scale you have. Let's just have a healthy ecosystem with a lot of mom and pop shops and individuals having a level playing field. But it would just seem to me as this space evolves that there would, in some respects, am I wrong in thinking that this could be a great enabler for the mom and pop shop, the people that don't have? I worked at Wang Laboratories up in Boston in my research and development. We had floors of computer scientists and engineers working on things. It seems like this becomes an invaluable resource to a handful of really smart people without a lot of capital to accelerate. Am I missing that, or would you all generally agree with that? Where's the risk to the small inventor that I'm missing?
As I said in my opening statement, I think that AI is going to be very ubiquitous in the invention creation process and just use. And so I think it will raise the boats for everyone, and I think it will make mom and pop businesses much more productive and efficient as well.
I'll just say I think that one of the really amazing things about AI is it does help democratize the innovation process.
Exactly the word I've used.
Yeah, and it puts in the hands of a far greater number of people, including people who wouldn't necessarily have had the funds to do these things before, an enormously powerful set of tools to innovate. And I think, if we play our cards right with the policy side of it, we as a country will benefit from that.
Mr. Abbott?
No, I would agree with that and mention that Dr. Thaler's business is a small business located in the Midwest. And, we've seen this particularly with the generative AI systems and copyright. Now I can make creative things that I couldn't have made before if I wasn't a major motion picture. I mean, they're still pretty bad, but, I have these tools and I can make something with them.
I agree, and we're seeing how it can be useful in the patenting process itself in terms of drafting of an application. How can these tools be used to help someone, get their ideas down on paper as a starting point? So that's yet another way it can kind of help assist in the patenting process.
I would agree with that as well, with the one caveat that I do think it's important that you also have human supervision and human review of the outputs. We've seen report after report of situations where ChatGPT and the equivalent were used and the results ended up being inaccurate. So I think right now it's a balance until we are more assured that the outputs are reporting accurate data, even for a small business, that they're actually getting the right answer that they're looking for.
And that gets into the whatever models you're using and whether or not they're secure, whether or not they're relying on a base of data that produces a safe or sound result.
That's right. The quality of the data is very, very important.
Yeah. Well, I think this is going to be one of many hearings that we have on this and maybe work groups as we move forward if we can find any areas for legislative action. I thank you all for your testimony today, and I thank the audience for participating as well. Thank you, Mr. Chair.
Thank you, Senator Tillis. I understand Senator Blumenthal would like a second round question. Then I have 2 or 3, and then we will conclude. Senator Blumenthal.
Yes, thanks, Mr. Chairman. And I will be very brief. I would ask each of you, not here but in writing afterward, to address 2 questions. One may seem pretty simple. Mr. Salsberg, in your prepared remarks, you talk about generative chemistry and how your company has developed new potential treatments for malaria. which is extremely promising. I would like from each of you pick 3, 5 of the most positive developments, inventions, but emphasizing the positive, because around here we tend to be talking a lot about the dangers and the harms, because that's what attracts people's attention, the potential for extinction. Not my word, but as you know, a word used by many experts in the industry to raise the potential for harm. So the second question I have for you, which doesn't really relate to your reason for being here today, is jobs, employment impacts on our economy. For me, what keeps me up at night, one of the main reasons to stay awake when thinking about AI, is the impact on our economy. I think we're on the verge of another industrial revolution, or the equivalent of the industrial revolution, when many, many jobs were destroyed in the course of raising the level of productivity for the jobs that were then created as a result of industrialization, and the people who tried to stop it, obviously the Luddites and so forth, failed, but there was a lot of human impact there. Maybe if you could address that issue. And then maybe now, or in written testimony, in written submissions, on the issue of open source. Senator Hawley and I wrote to Meta earlier this week about an AI model they released to the public in February. I'm sure you're familiar with it, the Llama AI model. And open source software obviously can be an enormously important resource for innovation and invention, for science, standards, transparency. It can foster competition. At the same time, even in the near term, that kind of generative AI tool can be dangerously abused. And we raised this issue in our letter to Meta. Once the AI model and software are out there, there's no reeling it back. And Meta didn't seem to put a lot of thought into the risk before they released Llama. That's an issue, in my view. Senator Hawley and my subcommittee will consider this an issue. Open source, enormously promising, also potential dangers. I don't know whether any of you now or in writing would like to offer some observations.
Thank you, Senator. We are working on assessing the implications of open source models and trying to come up with some policy recommendations, and we'd be happy to get back to your office on that.
Thank you. Any others? Ms. Sheridan, did you have any thoughts?
Similar to what Ms. Elluru shared, everyone's taking a look at this question right now and how it fits into responsible AI innovation. So we'll certainly follow up with more after the hearing.
But I think all of you would agree that there's a need for thought and consideration here before these models are just thrown into the wild, so to speak, correct? Thank you all. For the record, the witnesses are not.
Thank you, Senator Blumenthal. I'm just going to ask 3 quick questions, then we'll conclude. Ms. Elluru, if I might, just on the question of patent eligibility, about Section 101 law, something we're going to be turning to in a future hearing. How does the patent eligibility status of core AI technologies and technologies applying AI under U.S. law compare to eligibility under competitors, Europe, China? And is there a reason that the United States should adopt a different eligibility test? Is it necessary to harmonize eligibility laws globally as we consider the role AI and other emerging technologies are playing in that race for critical technologies, in which AI is a critical facilitating technology that you described in your opening statement?
That's a great question, Senator. Thank you. I think generally speaking, eligibility is not a hurdle in the EU. Their law for exceptions is written pretty narrowly, and it's interpreted narrowly. There's no dogma from courts deciding what is patentable and what is not patentable. I think China has a similar picture. They however, stopped publishing patent filing data in 2020. So it's hard to get a picture of what's going on there. However, I would say, based on data from the last few years, they were trending towards being more liberal in their allowances for patent eligibility. That is not the case in the United States. Since 2010, the patent eligibility uncertainty has only expanded, and that's leading to unpredictability. And so the patent incentives are
patent eligibility has only expanded?
But exceptions have only expanded.
Thank you. Just want to make sure I understood.
And so that is leading to uncertainty and unpredictability and weakening the patent incentive. There is no incentive to invent in the first place, and if there are inventions, it's not shared with the public and is kept as a trade secret. Either scenario is bad for innovation. As far as harmonization, I think we need to be consistent with other jurisdictions. I think different eligibility barriers for companies is burdensome, which is not good for the innovation ecosystem. And the United States should not be an unwelcoming jurisdiction with respect to patent eligibility. Patent eligibility has implications on funding, job growth, the economy. And so I think we need to be consistent, especially with the partners and allies that we want to collaborate with.
Thank you. Well stated. Briefly, if I could, Professor Villasenor, Professor Abbott, is it something we should be concerned about, that either a private actor or a state actor is going to use AI to either write and file a very large number of patent applications in an attempt to lock up patenting opportunities, or will draft and publish a large number of prior art publications to prevent inventors from obtaining patents in an entire field? Is this likely? Is it something we can forestall? And what, if any, advice would you have for us on policy in this area, if you would, Professor?
So I do think it's a concern. I think when there are the incentives in place, which with the continued advance of generative AI will be there, I think it's possible that either a private entity and or a state actor might do exactly what you've asked in your question. The particular policy responses depend specifically on what the pattern is. It's very different if someone is publishing massive databases of online preemptive prior art as opposed to filing massive numbers of patent applications. For the patent applications, there's some friction. It costs money, for example, and utility applications are examined. But I do think it's a sort of a watch this space area where I do think we need to be agile with looking at how the patent system might be used or misused in that way and responding to it.
And Ms. Sheridan, would the idea of raising patent fees have any deterrent impact on this?
It certainly would, and with the caveat, of course, that we're just talking about for large entities. But right. Yes, raising fees would disincentivize that sort of behavior.
Professor Abbott?
Some slightly different thoughts on that. I mean, if the concern is that AI is going to be generating so much invention that it's filing a lot of applications on legitimate ingenuity, I don't think that's a bad outcome. It means we have too much good stuff. If an actor was deliberately filing bogus patent applications to try and jam up the USPTO, I think that's something we would have more of a technical solution to. As to someone publishing a massive database...
What would that technical solution be, sir?
Oh, well, I mean, if it was getting an overwhelming number of kind of auto-generated applications, then, the patent office is also leveraging its use of AI and might have AI trying to detect kind of the use of inappropriate filings that don't have legitimate claim and specification structures in it, for example. So detecting essentially just fake applications. But, that might be a complex subject. To the extent someone's just publishing a whole lot of data to try and keep people from getting patents, that is something I think patent law might have a solution to, because prior art has to be anticipatory and enabling. And I would say if somewhere in a trillion document database, somewhere there's some disclosure related to an application that no one could usefully access or use, that would not be an enabling anticipatory disclosure. But that might also be something that if you are considering amending the Patent Act, the Congress could clarify.
Last question, Ms. Elluru. I think you raised, but I've also heard about data being just as important when it comes to AI as patents. And China allegedly is experimenting with a new form of IP rights in data because of its relevance to this race to be preeminent in AI. Should we be exploring similar rights around data sets that would be designed to incentivize innovation and promote disclosure and transparency, some of the core goals of the patent law?
That's a great question, Senator. Thank you very much. In short, yes. Data is a critical input to the innovation ecosystem. We should be treating data across our industry, public sector, and academia as a strategic asset. So we need comprehensive data strategies to maximize the value of that data. That comprehensive data strategy should include several components, including data privacy, of course, but it should also explore intellectual property rights in data. Is it going to incentivize data-related inventions? Will it incentivize data-driven products and services that are great for the public? Is it going to help raise our economy, increase our economy? It's estimated that the market for data in a few years will be over $1 trillion. Will intellectual property rights and data help increase that economy? And I think that is something we should explore.
We might be able to continue that discussion in our next hearing, which will be about the intersection of AI and copyright. I'm so grateful to Senator Tillis, his staff, for making this possible, to all of you for bearing with us, for your great testimony, to the members of the committee who came and asked questions. I will mention it's important technically that I say members can submit questions for the record for you, the witnesses. They're due by 5 p.m. a week from today on June 14th. And with that, this hearing is adjourned.